discuss the essentials of offer. As you can see on the board, I have written different points along with the case studies connected with it. So the first point is contractual relationship. For any offer, there must be certain contractual relationship. There must be intention for any kind of legal obligation on the part of the parties. Say with an example, A gives an offer to B for dinner. Suppose if A fails to perform the dinner for B, then B cannot sue A because there was no contractual relation between them. For any contract, there must be contractual obligation on the part of parties. This example is connected with personal nature. So, if A does not arrange dinner for B, B cannot make it voidable on the part of A's promise. So, you can see I have written one case, that is Balfour versus Balfour. In Balfour versus Balfour, a couple was staying in Ceylon and they went for London for summer vacations. There, the wife, Mrs. Balfour, got seriously ill. Hence, husband left her wife there in a hospital and he promised that he will be sending every month 30 pounds. After going back to Ceylon, husband did not send the money. So, wife sued the husband in the court of law. The court held that it was having no kind of contractual obligation on the part of parties. Hence, the Balfour cannot claim the amount. Mrs. Balfour cannot claim the amount on the part of its obligation, on the part of promise given by her husband. So, first point is clear, I hope. Second is, the offer must be for certain things. The offer must be for certain things. It must contain certainty. For any contract, there must be certainty. It must not be uncertain. Suppose A gives an offer to B for rupees 1000 if the house proves to be lucky. Now, the house may be proving lucky or it may not proving lucky. For A, it depends upon the event which may happen, which may not happen. So, in that situation, we can't say that it is certain offer. It might be uncertain also. So, as you can see, I have written one case study. This is Taylor versus Porrington. In Taylor versus Porrington, there were two parties. One party promised to take the house on lease for 3 years, but a condition was given that the house should be constructed in proper style given by the party. So you can see that the contract was not formed, hence it was created on the basis of uncertain events. Now the house construction, that too depending upon the other party's choice and will, it cannot be created. So you can see that offer must have certain things to be in it. Third, general offer or specific offer. An offer can be of two types, that is general offer or specific type. That is, general offer is given to public at large, but in specific offer it is given to specific person or specific group of person. Say with an example, an offer is given in a form of advertisement. So that is general offer. It can be accepted by any party. Say an offer is given by A to B for some specific performance. So it is specific offer. Now you can see the case Carlin versus Carbolic Smoke Ball Company. In Carlin versus Carbolic Smoke Ball Company, there is one company by name Carbolic Smoke Ball. It has created one medicine by name Smoke Ball. If anyone who is contracted with the disease by name influenza takes that medicine, the company will be giving a reward. That is, the reward will be for 100 pounds. If anyone is cured by taking the medicine given by the Smoke Ball Company, if it is taken in a proper course of manner, in proper due care, the company will be giving 100 pounds. Now, Mrs. Carlin has taken the medicine and she was not cured by the name influenza disease. So she filed a case against the company stating that it was a general offer and the company has given advertisement in the newspaper regarding the reward. But the company's contention was that it is a general offer and hence it is a general public and hence anyone can accept it. So the company is not liable for it. But the court said that it is a valid offer. An offer can be of general offer or specific offer. So in this case, general offer was challenged. The next point is the offer must be communicated to the offeree. Always an offer must be communicated to the offeree. Without communication of offer, the contract will cannot be completed. The contract will not come to an end. So always the offerer should communicate the offer to the offeree. There is one case by name Lalman Shukla versus Gauri Dutt. In Lalman Shukla versus Gauri Dutt, the Gauri Dutt has lost her nephew, so she sent Lalman Shukla for search of her nephew. Later on, she has advertised in a newspaper for reward that whosoever found her lost nephew will be rewarded. After that, Lalman Shukla brought her nephew, and after giving the nephew, he saw the advertisement in the newspaper and he claimed for the reward. But Gauri Dutt refused to pay the amount and he filed a case against Gauri Dutt. The court said that the offer is not communicated to you directly, so hence it is not a valid offer. For any contract, the offer must be communicated to the party. So this point is clear. The next point is, the offer must be different from invitation to an offer. What is invitation to an offer? Invitation to an offer means which invites the person to accept the offer. Say with an example, display of circulars, display of any kind of catalog, or display of any kind of price tags in a shop will be considered as invitation to an offer. So as you can see, invitation to an offer, I have written one case study, that is Harvey versus Fessy. In Harvey versus Fessy, Harvey has given 3 telegrams exchanged to Fessy. The first telegram exchanged by Harvey was regarding the bumper hall pen. The Harvey has given an offer for bumper hall pen. Bumper hall pen is a kind of property of Fessy. So he has asked an offer for bumper hall pen. How much will be the value of bumper hall pen? Kindly quote the lowest price of it. So second telegram was exchanged by Fessy to Harvey. The lowest price is 900 pounds. Third telegram given by Harvey to Fessy was, I accept your offer and hence I am ready to purchase it. But Fessy did not reply for it. So Harvey has filed a case against Fessy in the court of law, stating that he has accepted the offer and he is not ready to perform. The court said that mere statement of acceptance of what you call lowest price will not be considered as offer. It is just an invitation to an offer. So friends, I hope that you have understood the concept.